Welcome to Rahman and Rahman Legal Insights. Today we're going to discuss the impact of COVID-19 on construction contract claims. The COVID-19 pandemic has already had an extreme impact across the globe, including South Africa and the lockdown, which has resulted in construction sites being shut down and has already resulted in substantial delays in claims. In addition, the consequences of the global pandemic will be felt for some time to come. For example, in the availability of materials, which will be reduced due to transportation difficulties. International procurement will also consequently be impacted, which includes specialist international human resources and the compounding effect of balancing the risks of potential compromise to the health and safety of the workers and resulting reduction in available labor. So what should contractors do to protect themselves in terms of their construction contracts? Well, first and most important step for contractors is to give timeliest notice of any delays and to advise parties related to the project. Although all construction contracts have a time limit for such notification to be delivered, contractors must still pay careful attention to the contract-specific requirements for notice of the delay. There may also be contract-specific inclusions in a force majeure style, which might be relevant given the South African government's intervention in declaring a national state of disaster and effectively enforcing site closure. In addition to the site closure, as an identifiable cause of delay, there may be other specific underlying events giving rise to a claim, and these should be identified by the contractors. Where the origin of the particular event or delay or impediment arises as a consequence of COVID-19 and the attendant lockdown, a contractor would have to make a claim in accordance with the claims provisions in each specific contract. I will now briefly touch upon a few of the standard forms of contracts that are used in South Africa. Clause 5.12.2.4 of the GCC 2015 contracts. This entitles a contractor to an extension of time for any disruption caused which is entirely beyond the contractor's control, and COVID-19 may also fall within the definition of accepted risk, and in particular the reference to epidemic plague as set out in clause 8.3.1.7. The contractor would be entitled to payment of any increased cost attributable to COVID-19 as an accepted risk for the disruption of site closure, and although it is unlikely that contractors would wish to terminate the construction contracts, be aware that if the accepted risk or disruption has a material impact on the project for more than 20 consecutive days, either party may be entitled to terminate the agreement. In the JBCC agreements, from Edition 6 onwards, force majeure is recognized and defined as an exceptional event or circumstance that A. could not have been reasonably foreseen, B. is beyond the control of the parties, and C. could not reasonably have been avoided or overcome. The global pandemic would therefore fall within that definition, and consequently delays which are caused due to COVID-19 would entitle a contractor to make a claim for revision of the date of practical completion in terms of clause 23.1.6. Clause 23.1.5 also allows for a revision to the date of practical completion, where an exercise of a statutory power by a body of state directly affects the execution of the works. No doubt, the state's declaration of the national state of disaster and the consequential lockdown would fall within that provision too. A contractor would, however, not be entitled to an adjustment of the contract value for any such delay, and we have to stress that either party may still terminate the agreement where progress of the works has ceased for a continuous period of 90 calendar days. Under the NEC 4 contracts, a compensation event is defined in clause 60.1 as an event which stops the contractor completing the whole of the work and which neither party could prevent, and that an experienced contractor would have judged at contract date to have had such a small chance of occurring that it would have been unreasonably unforeseeable to allow for it. COVID-19 should fall within that definition too. A contractor must notify the project manager of a compensation event in accordance with clause 61.3 as the project manager must determine if the contractor's notification is accepted as a compensation event and instruct the contractor to submit quotations which could impact the contract price and/or completion date. In clause 91.7, the employer will still have the option to terminate if the works are prevented from completion and would result in a delay in completion of more than 13 weeks. COVID-19 ought to by now form part of the risk register and have to be proactively managed to reduce its impact on the project. Under the FIDIC 2010 agreements, Clause 19.1 defines force majeure as an exceptional event or circumstance, which A. is beyond a party's control, B. such party could not reasonably have provided against before entering into the contract, C. having arisen, such party could not reasonably have avoided or overcome, and D. is not substantially attributable to the other party. The contractor would have to give notice of the circumstances and underlying origin of the claim in terms of clause 19.2. And once notice has been given, the contractor would be entitled to an extension of time for the delay, but the contractor would not be entitled to additional payment. Again, either party may cancel the contract if a substantial portion of the work is prevented for a continuous period of 84 days. So in conclusion, while the above is merely a brief overview and by no means a comprehensive analysis, it is evident that the most important commonality between all the contracts is that the contractors must give notice of the delays arising from COVID-19 and the attendant site closures as soon as possible. The delays and impacts on the project should be set out clearly in the delay notice, and contractors must comply strictly with the contract notification requirements of each contract. Contractors will have to consider whether the identified delay claim will entitle them to simply claim further time for completion without penalty, or whether they will be entitled to claim their additional cost arising from the delay. As this brief analysis shows, this will be dependent on each contract's form and a careful consideration of any special conditions. If your project is affected, please do get in touch with us as soon as possible in order for us to assist you understand the risks and remedies available to you, which you may even extend to a possible company restructure in order to limit the effects on your business and staff. We hope you have gained some valuable insight out of this overview. And as I said, if you require further information, kindly contact our offices at Rahman and Rahman Incorporated.